and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods. And on behalf of our presenting partners with the Texas Legal Services Center, we have joining us today Ms. Lisa Nelson. Also presenting on behalf of our partner is the Harris Central Appraisal District. We have Ms. Mabel Menifee, as well as with the Harris County Tax Assessor Collector's Office. We have presenting will be Ms. Jamie Duong and Ms. Shay Pinkowski. But also included in the partnership, we also have, excuse me, Lone Star Legal Aid, the Houston Bar Association, Houston Volunteer Lawyers, Lone Star Legal Aid, and together we make up a month of service. And basically what a month of service is, it's the collaboration of all of our organizations. We come together on a monthly basis and offer a variety of different workshops, resources, information to the community relative to asset building, asset protection, community empowerment, and the maintaining of generational wealth. We started several years ago with this collective and choosing to collaborate to try to create a larger impact and reach more people throughout the city of Houston and Harris County. I'll be right back. However, switching to the virtual platform has allowed us the opportunity to reach even more people in surrounding counties and throughout the entire state and actually even across the country. So we know that there are a lot of underserved communities that are out there that don't have access to a lot of information, that don't have access to resources and don't know where to go for particular help. So again, we decided to collaborate so that we can get as much information out to the community as we possibly can. So we want to welcome you on behalf of A Month of Service. This is your opportunity to ask whatever questions that it is that you have in relation to our topic for today. If you do find yourself in need of some, real particular situation about your particular circumstance, we ask that you try to contact the presenters or any of our partners outside of this presentation because we are recording as well as broadcasting live on our social media platforms on YouTube, as well as the link will be provided on Facebook as well. So we want to try to protect your privacy as much as we possibly can and ask that you don't divulge any detailed information about your particular situation or your personal, your name, your address, and things like that. So we don't want that information getting out there to the public. Also know that the information that we do provide here today is for educational purposes only. It is not to be considered legal advice, but again, we do encourage you to reach out to our presenters and our legal service partners if you have a need for some assistance for any civil legal matters, or if you have questions in regards to your property tax bills or payment options that you may need as it relates to these topics. So we want to welcome you. Thank you for coming. If you have questions, please feel free to type those into the chat. There will be somebody monitoring from each of the presenters' offices that can answer your direct question. If you are joining us on our social media platform, feel free to type your question into the comment section and I'll be monitoring that and we'll be asking those questions aloud at the end of the presentation as well. So with that being said, I think we are going to move right on into our introductions and get started with your program. There's a lot of information that's going to be covered here today. And again, we do encourage you to ask questions. We know, again, that a lot of folks that don't have access to a lot of information and some things may come up as the presentations go along. So we do encourage you to be interactive. So with that being said, Ms. Mabel, why don't we start with you? And I'm not sure if Shay can connect, but we can get her introduced. And then Ms. Lisa will have you introduce yourself last, and then you can move right on into the presentation.
Sure. Thank you, Nia. Good afternoon, everyone. As Nia said, my name is Mabel Menifee, and I'm with the Harris Central Appraisal District. I'm here today to sort of help fill in some of the blanks for you as after Lisa goes through her presentation about clearing title on inherited property, because often a lot of those questions tend to have something to do with exemptions and property taxes and that sort of thing. So hopefully we can provide you with answers today. If we cannot, and your question is one that might have to be researched first, we will certainly be happy to do that and get back with you. I'm also on today with my colleague, Rosalind Alexander, who is going to be listening in and will be able to help you with some of those questions as well. And again, if not, we will get back with you. But I'm looking forward to speaking with you following Lisa's presentation. And on behalf of the Aimless Partnership, thank you for joining us today.
Okay, I think Shay is still having trouble connecting, so we'll make sure that you get introduced right before you guys go to present Shay between you and Jamie. So Miss Lisa, why don't we have you go ahead?
Good afternoon, everyone, and thank you for joining us today. I am a staff attorney with the Texas Legal Service Center. It's located in Austin, but I am here locally in Houston, and we service pro se people, which is people who don't have their own attorneys throughout the state. I will be glad to answer your questions after all of the presentations are finished, and I'm going to go ahead and get into my presentation now. So this presentation is on clearing title and other property concerns. This is kind of a combination of a couple of topics. Clearing title is a critical issue in our community, but I also like to use the time to talk about what happens in the probate process. This is the last part of our probate series. We have the, why you need estate planning and other legal documents, and then we have the create your own estate plan. And I show how those documents are used and how they go into effect once someone has passed. So I'm going to give you an overview about probate, and then I'm going to talk about the main subject of today, clearing title to inherited property, and then how to make sure the property stays in the family, that it's transferred correctly to your heirs. And then finally, I'm going to pass it over to Mabel and the people at the tax assessors, Mabel with Harris Central Appraisal District, and our friends also at the tax assessor's office, so that they can give you an overview of property taxes. Texas Legal Service Center is a statewide nonprofit that provides legal advice, advocacy, representation, and education to underserved people across the state. We have more than a dozen practice areas, and we touch almost every aspect of civil law affecting low-income Texans. So probate has a lot of vocabulary that hopefully will become second nature to you. The decedent is the person who passed away. If you pass away with a will, you're known as a testate person or a testate estate. Intestate is when someone dies without leaving a will. Testator is the person who signs the will. That's is the term we use during the will signing ceremony. And a will is just a legal document that states how the testator's property is to be distributed at death. Estate is all of the property that is owned at the time the person passes away. And probate is the court process of winding up a person's affairs. It's called administration if there is no will. And executor, administrator, personal representative can be interchangeable, but an executor is the name of someone who is named in a will to wrap up the person's affairs and distribute assets to the beneficiary. If there is no will, they're known as an administrator. An heir or beneficiary is the person who inherits by law. Or I'm sorry, by the will or by law. There's a lot of common misperceptions. I used to work for somebody who called people street lawyers, because people hear things by word of mouth and then it gets passed around and people misunderstand the process of the law. Powers of attorney are only valid when you're alive. Once a person passes, the power of attorney is void. Spouses need to have separate wills. I think at one point it may have been common to have a joint will, but that's not legally valid anymore. A surviving spouse has a life estate in the deceased person's home, even if it's separate property. So here in Texas, we have community property, and a lot of married couples think we don't really need to have a will because everything's community property, right? That's not necessarily true. Lots of times people will get married to someone who already owned a home. That is separate property. Now, the surviving spouse does have a right to live in the house until they pass, but if someone gets married who has children from another relationship and they don't have a will, half of that house goes to the children. And the executor or administrator is disqualified by law if they are under 18, which is known as incapacitated, have a felony conviction, or live outside the state of Texas. It is best to have an attorney prepare or at least review your will. And I'm sure Miss Nia will bring this up near the end of the presentation, but we are going to have a pro se clinic later this month where if you have your estate planning documents drawn up, you can bring them in and there will be attorneys who can review them and make sure that they're okay. A lot of people will use forms that they find off the internet, such as LegalZoom. You think it seems like a great deal, maybe it's just a few $100s. The problem is those wills may not necessarily be valid. They're written to be as generic as possible, and often they are not in compliance with Texas law. And I have seen people end up spending a lot of money on lawyers and courts because, you know, a parent decided that, oh, I just need a form. I don't have to go to a lawyer, and the form's not valid. Our website, texaslawhelp.org, does have do-it-yourself will forms that are approved by the Texas Supreme Court. It is absolutely fine to use those forms, but even using a valid forms, it's good to have it looked at by a lawyer. And Texas law does allow you to handwrite your will. It's known as a holographic will. It has to be completely in your handwriting, and that can be either printed or cursive, just whatever your day-to-day normal handwriting is. And if you go to texaslawhelp.org, you can see some information on that. It's really important to keep your will in a safe place and let your loved ones know where that will is. People will put their papers in a safe deposit box, and then when they pass, the loved one finds out, I don't have permission. I'm not on the safe deposit account. And they have to go through court just to get permission to get that will out of the safe deposit box. So make sure that your family knows that you have a will, where your will is, and if it's at a bank, that they make sure that one person has the legal right to enter that safe deposit box and get everything out. An important thing to know about Texas is if your original will is lost, Texas law presumes that the will has been torn up and is no longer valid. And you have to go through a lot more hoops if no one can find the original will. So please keep it in a safe spot that at least one person knows where it is. If you die without a legally valid will, the law determines who will inherit your property. And that's really important to think about, because if you pass away without a will, everything goes equally. Your spouse gets 50%, and then everything else is equally divided up against whoever can inherit from you. And it could be somebody that you don't want to inherit from you. It could be someone, you know, there could be someone very special in your life who's not the next in line according to Texas law. So it's important to make your wishes known in writing through a valid will. If you can't find a will for your loved one, you have to file an application for administration. There's two different types. There's dependent and independent, and I'll go into more detail on that in a little bit. In extremely limited cases, you can file a small estate affidavit. The small estate affidavit is the only process you can do without an attorney. Texas law requires you to have an attorney to probate your estate. And I always say, even if you think that a small estate affidavit is for you, it's a good idea to consult with an attorney to determine the best way to proceed, because there are numerous processes that can go through probate, and attorneys will know the best way to proceed. You don't even have to hire that attorney to do your probate. You can just consult with someone to get their advice and see what their recommendations are. Probate assets are the property in the testator's name that pass under a will. It could be your house, and it's also your personal property, your household items, your furniture, your clothes, all of those things. This is a great tip if you're a resident of Texas. Non-probate assets do not pass according to your will. They pass according to the terms of a contract. So that would be things like your life insurance, retirement plans, and payable on death accounts. I always ask people, please, this afternoon or first thing in the morning, check with your bank, check with your credit union, call all of the financial accounts that you have, and make sure that you have payable on death accounts. That way, it doesn't have to go through the probate, and your loved ones will have access to those funds much sooner. When I conclude about how to prevent any problems in the future, I'm going to strongly urge everyone to do a transfer on death deed. If you have a transfer on death deed and payable on death beneficiaries on your accounts, your family might not need to probate your will. And that saves them a lot of money and even more time. Small estate affidavits are very, very limited in what they can do. It can be used to transfer real estate only if it will be inherited by a surviving spouse or minor under the age of 18 child. If you are an adult child who's been living with your parent, being their caregiver, you cannot use a small estate affidavit to transfer the house. It only works for surviving spouses and minor children. And I might sound like a broken record with this, but I can't tell you how many times I have heard from clients or from the court that people do a small estate affidavit so that they don't have to have a lawyer, and then they're out $400 because the judge is only going to approve it under those limited circumstances. If you have no real estate and you only have, say, a small bank account to transfer, a small estate affidavit may work, but it absolutely does not work for property unless you're the surviving spouse. All heirs have to sign the small estate affidavit along with two disinterested witnesses. Two disinterested witnesses are people who knew the deceased person well, knew their family history, but are not legally able to inherit. So it could be a cousin, it could be an aunt, it could be your next door neighbor. It just has to be someone who knew the person well. You cannot have a small estate affidavit if the deceased person had a will that was legally valid. The value of the assets has to be greater than the debts of the estate. So for example, if you have an estate that's valued at $20,000, but you have $30,000 in debt, the judge will not approve the small estate affidavit. And finally, the estate, excluding the homestead, has to be less than $75,000. Your home is exempt. Probate procedures, and this is the same process in independent administration. You get an attorney who determines the best way to proceed. The attorney will file an application, either application for probate or application for administration. It has to be on record for 10 days before the attorney can schedule the hearing. That being said, if you are in Harris County, it may be 6 months or more before a court is available. Our courts, we just added a 5th probate court, and they're still extremely backed up. You have a very short, easy hearing in front of a judge. It always sounds intimidating to think that you have to be sworn under oath, but the judge just reviews the will. Your attorney will ask a few questions to prove to the judge that it's a valid will and it represents the person's wishes. Once the judge grants the application for probate or application for administration, the personal representative receives letters. Those letters are their legal permission to handle all the affairs of the estate. The personal representative has to gather all the assets and open a bank account for the estate. When someone passes away, within days, very, very quickly, the bank gets a notice of death and closes the account. So the person has to transfer the money from that account to another account that's owned by the estate of Mary Smith. The next step is the attorney notifies creditors. Family members are not responsible for a deceased person's death. I'm sorry, a deceased person's debt. The debt gets paid out of the assets of the estate, and that is it. The attorney notifies the creditors that an estate has been opened, and they have a limited period of time that they can file a claim, and it's a formal process. They have to file an official claim through the court. There is very specific language they have to use, and the attorney and the representative will determine if the debts are valid. Finally, the attorney and personal representative prepare and file an inventory. That is a document that states all of the estate assets as of the date of death. A lot of people in the community live in family homes and don't realize till there's a disaster that it's not legally their home yet. If you don't have clear title, you don't qualify for local, state, or federal assistance if there's a disaster. And you won't be eligible for property tax exemptions or deferrals if you're not the owner of record. A clear title means that no one else has a financial interest in your property. It also means that there is no question of ownership, and the ownership history of a property can be easily traced. If you do not have a clear title, which is property that's been legally transferred or deeded to the current owner, it's known as a cloudy title. This happens if somebody dies without a will or the family doesn't manage the estate. I have had plenty of situations where people don't probate a will because their parents were married and everything went to the surviving spouse. So they assume, I don't need to probate it. Everything goes to the other parent. That's not true. You always need to probate a will unless there's a transfer on death deed and payable on death beneficiaries. So just having a document stating my house goes to my spouse, then it goes to my niece, is not legally clearing title. You have to go through that court process. Filing a transfer on death deed is the easiest way to transfer real property to someone after you die. It's also important to prepare a will that's legally valid in Texas that can be used to transfer any property. Even if you have a transfer on death deed and you have beneficiaries to all your accounts, it's important to have a will just as a backup. And if you don't have clear title, you don't get disaster assistance. You don't get property tax relief. You cannot qualify for home improvement or any other type of loans. So again, it's really critical to either probate the will or go through the probate process known as administration when a loved one passes away. The easiest way to clear title is going through the courts. You are supposed to probate a will within 4 years or file an application for administration. If it's been more than 4 years, you can do a process that's called an application to probate will as muniment of title. What this is most commonly done for is if people don't know there's a will, they can't find a will. I didn't have this case, but I was in court one day when there was a woman whose husband had died 15 or 20 years ago, and she thought he didn't have a will. She just went around about her business. And as she was cleaning her house out because she was going to put it on the market, she found an old safe. And sure enough, she got that safe opened up and there was a will there. And the judge said, that's understandable. You didn't know there was a will. We'll go ahead and let you probate. And what muniment of title is it basically means the only thing I need to do to settle this estate is transfer this home to the person named in the deed. And you do have to have a good reason if it's been more than 4 years. Then there's a final process that I'll go about later. If you don't have clear title and it's way too late, or a court process, probate process would be difficult, you can file a petition for adverse possession if you meet the requirements. So again, if it's been 4 years, if it's been 4 years or less since the date of death, you probate a will or file an application for administration. In that case, the judge determines whether the decedent left a valid will that's compliant with Texas law. If there's no will, you file an application for administration. If it's been more than 4 years and there is a valid will, you can have the muniment of title. All the illegal heirs have to agree to probate the will. And I can tell you that this can be a headache. I had a situation when a gentleman didn't know that he needed to probate his mother's will, and he realized he and his mother owned the house together, and something happened and he realized he needed to get her name off the deed. She died in the 80s. I had to find every single one of her heirs. She had numerous children. Some of those children had passed. So there were about 40 people that I had to locate to sign off to get permission to transfer the will to this gentleman. It's a really simple process if everything works. The judge admits the will to probate, and then your attorney would file a certified copy of the order and the will, and then the property that will be filed in the real property office at the county clerk's office, and then the home will be transferred to the person named in the will. Adverse possession is something you've probably heard about. It's where you meet certain requirements. You have to have lived at least 15 years in the property. It has to, you have to be, basically it has to be open and notorious and adverse. So open means everybody knows that's your property. Maybe it's a lot next door that you keep the grass cut, you have a garden on there, you've set up a swing set, whatever, but everybody knows that's your property. You take care of it. You've gotten mail there. You pay the property taxes there. You meet all these things. If you have permission to use that property, you cannot get adverse possession. I had an unfortunate situation where this woman lived in her aunt's house, and everybody in the family was fine with her living there, but they would not sign over her to give her 100% ownership of the house. She could not use adverse possession because she had permission to live there. And the easiest, least expensive way, especially if the person has been passed for a very long time, is an affidavit of heirship. It's a legal document that transfers the property to all heirs of a person who has passed away. We use it when someone dies without a will, or if it's been many years. They may have had a will, but it's been more than 4 years, and this is the easiest way to transfer it. This can be done without an attorney. There's a guided form with instructions at texaslawhelp.org. It has to be signed and notarized by 2 people who knew the deceased person well and their family history. It's critical that you have the full legal description, which is found in the deed. The legal description on your property tax bill is not the full legal description. It's confusing because on your tax bill it will say legal description, but that's an abbreviated description. The full description is much longer, and how you know it is correct is it will say, as recorded on volume whatever, page whatever, in the deed records of Harris County, Texas, or whichever county the property is located in. If you can't locate that deed, you can get deeds through your county clerk. You can also, there's websites online. I think it's called Texas Doc that you can get. It's just it's $1, I believe, a page for either of those ways. And I experimented with the Texas Doc website, and I didn't have any trouble finding my deed, and it was correct. The difference between a small estate affidavit and an affidavit of heirship is important to know. Again, a small estate affidavit can only be used to transfer property if there's a surviving spouse or children under the age of 18. If you don't need to clear title, you can absolutely use a small estate affidavit to transfer other assets, as long as you meet all the requirements. Affidavit of heirship is the best way to transfer a home to adult children or other legal heirs. You can use an affidavit of heirship to transfer a property to a surviving spouse if there's no other assets in the estate. That would be, you don't need to worry about a bank account. You don't need to worry about any other property that needs to have a legal transfer. Once you go through the process of clearing title, it is really important for you to plan ahead so that your heirs don't go through the same efforts. Transfer on death deed is a fabulous, very simple and inexpensive way for you to transfer any real estate to someone upon your death. Transfer on death deed absolutely does not affect the owner's rights during their lifetime. So the owner can still sell the property. They can use it as collateral for loans. They still are eligible for all their property tax exemptions and deferrals. And the beneficiary has absolutely no rights until the owner passes away. Then their deed is revocable, which means the owner can change the beneficiaries or cancel the deed entirely. And the only way for the transfer on death deed to be valid is that it has to be filed before you pass away in the county where the real property is located. And one thing that I like to talk about transfer on death deeds, if you go through probate, it could be a few $1,000s. If people fight, it could even be more than a few $1,000s. If you use a transfer on death deed to transfer your house and you have payable on death beneficiaries on all of your bank accounts, it's only going to cost them a small amount of money. You pay $40 to $50 to record that transfer on death deed. Once a person passes away, the beneficiary files what is known as an affidavit of death, takes that to the property office, and the house is theirs. We have a very good guided form on how to do transfer on death deeds on our website. Just like the affidavit of heirship, you need to get an existing deed to get the full legal description. You want to have that full legal description because otherwise your transfer on death deed is null and void. Transfer on death deeds also protects your property from Medicaid estate recovery. If someone uses Medicaid to pay for their nursing home, Medicaid has the right to get their assets back, to get their investment back in you by going through probate and forcing the sale of a home. Texas law allows you to transfer your house with this deed, and if you don't go through the probate court, Medicaid cannot seek any recovery. So it's a great benefit to your family. Our partners have a lot of wonderful legal resources for all of you. We have a website and we provide free legal advice. Earl Carl has a property preservation program that gives you legal assistance with anything to do with housing. Lone Star Legal Aid and Houston Volunteer Lawyers provide all the civil legal assistance you could need. Houston Bar Association has a great service that's free. It's called Legal Line. You can sign up for it. It's I think it's 2 or 3 times a month. And once a month, they do have it in Spanish. You sign up for it and you get a free consultation with an attorney. The attorney cannot take your case, but they are able to give you advice. Houston Lawyer Referral Service maintains lists of attorneys that take certain cases, and you get a 30-minute consult for $20. Thank you very much. I'm going to pass it over to Mabel, and I'll be here for your questions afterwards.
Was your contact information on that slide also, Ms. Lisa? For
You
folks that
know,
are doing
I'll
phone?
put it in the chat. I don't know if it is. Oh, you put our website. So
Yeah, the website is there.
Yeah, I'll put my contact information in the chat, and I can give it out again when it's my turn for questions.
Okay, there was a quick question that was put in the chat a while ago. A transfer on death deed, is that done through the title company?
No, you do either an attorney does it or you do it yourself. The title company is not involved.
Okay. All right, as Miss Mabel is getting ready, for those that are kind of wondering, why is the tax office involved or why is the tax office here? When it comes to clearing title or dealing with inherited property, a lot of times you will find that there are multiple heirs. Sometimes there may be somebody that's still living in the property, and there are various exemptions that are out there that that heirs can actually take advantage of. Even though they are not 100% owner, and Miss Mabel's going to go into all of that. In addition to that, oh, it was up, Miss Mabel, you had it.
Oh, okay. I couldn't see myself. All right, hold on.
So in addition to that, sometimes you will find yourselves in the position where property that you're getting ready to inherit or the heirs will inherit, and there's a tax bill that's due. And Jamie's going to get into the details about the tax bills and when they actually become due. But because seniors are eligible for a tax deferral, there's a lot of confusion sometimes when they are applying for an exemption versus a deferral. And being that there is a deferral, sometimes when property tax bills are not paid, the heirs are left to actually have to pay those bills that have been deferred for multiple years, sometimes, 5, 10 years or what have you. And those tax bills, are due. So that's kind of why we chose to kind of include tax assessor collector's office here to kind of let you know what happens after someone passes and what potential things can kind of come up when it's dealing with clearing title and that inherited property. So Ms. Mabel, your presentation is up on the screen, so go right ahead and get started.
I certainly will. Thank you, Nia. And thank you, Lisa. Again, my name is Mabel Menifee. I'm with Harris Central Appraisal District. And Lisa some time ago invited us to come on with her to sort of do a backup presentation to hers on about clearing title, because there's so many issues surrounding clearing title and inherited property that actually have to do with property taxes and the history of ownership of that particular piece of property. So I'm going to quickly go over some of those details to sort of help put that in perspective into how sometimes property taxes can be a major part of the process. So just to get started, I'm going to go ahead and just kind of quickly, and this is just information I think everyone knows why we have property taxes in the state of Texas, and why they play such an outsized role is because there's no income tax, and they pay for schools and public education, police, and that sort of thing. So I think most of us all know that. We are a lot of people call us, we're HCAD for short. We used to be called the Harris County Appraisal District. We changed our name a few years ago to Harris Central Appraisal District, primarily to sort of help do our part in trying to clear up some of the confusion about what appraisal districts are versus what county government and other taxing jurisdictions are. So appraisal districts are responsible for appraising all the property in the county. That includes all residential, commercial, ag, industrial, and business personal. And we do that once a year. And we also administer exemptions. Exemptions are going to be an important part of that puzzle in terms of when property is transferred, because exemptions do not go with the property. They are based on the qualifications of the individual owner at that time. So we're going to talk a little bit about that. And then finally, our main goal in terms of what we do each year for all the other processes is that we certify the appraisal rolls for all of the taxing jurisdictions. And that means that we say to those taxing jurisdictions, and those are city, county, your hospital district, your school district. Here is the certified appraisal roll. In other words, this is the value of property within Harris County. Now that you know that, you can go ahead and set your rates, your tax rates, and your budgets based on that information. So just kind of, we operate, I said, on an annual basis. So sometimes getting things in before certain deadlines is important because we have to provide the information year after year after year. And so here's some of the important deadlines for that. We appraise all property based on its condition as of January the 1st of each year. So to kind of clear up some confusion on that, whatever your house was valued at on January the 1st is what your property taxes are going to be based on, unless you file an appeal and get that amount changed, usually lowered sometimes. And I say that because you could have a fire on that home, and say a bedroom is destroyed on January the 5th. However, your tax bill, or not your tax bill, but your your valuation notice that you receive from the appraisal district is going to be based on the condition that the property was in on January the 1st. If however, the next January rolls around and there has been no improvement, you haven't been able to repair that that damage yet, then of course, that's when the lower value is going to be reflected in most cases. The May 15th protest deadline, that's generally because you get properties owners are sent their evaluation notices usually in late March or early May, sometimes later. But that is typically the standard protest deadline. And then of course, October, November rolls around, that's when you receive your tax bills. Your tax bills do not come from HCAD, they come from tax assessor collectors, and the Harris County Tax Assessor Collector folks will be on shortly to kind of go over a little bit about that process, because payments sometimes are going to be very important too when we're talking about inheriting and clearing title on property. Then of course, every year, any property taxes that have not been paid by February the 1st are going to be delinquent, and that's when you're going to start accruing interest and penalty charges. At HCAD, we are required to be, by the tax code, to be at 100% of market value. So each year we're going to look at the sales and determine the value of the property based on what similar properties are selling for in that area. Again, it's important to know that the value derived is going to be based on the sales. At HCAD, we are the largest appraisal district in the nation that appraises annually. And we do appraise approximately 1.9 million parcels of land annually, and that is for over 500 taxing jurisdictions. Most tax bills are only going to reflect 5 or 6 jurisdictions that you may pay to. It depends on where you live in the county, but keep in mind that there are over 500 for different things. This is just what the valuation notice, should it come in the mail, looks like each year. Usually comes around April or May. It's going to show the appraised value. It's going to show the market value. The appraised value is the value in which your taxes are going to be based. The market value is what HCAD determines each year. Now, why are those two different numbers? One is because the appraised value may often be lower than the market value, and that's going to be because of the exemptions that are on the property. Remember, exemptions belong to the person who qualified for them. They're not attached to the property itself. So that's important to remember when a loved one or relative passes away and you inherit the property. The exemptions that were on there at that time, at the time of the previous owner, are probably no longer valid. So keeping in mind the appraised value, as I mentioned, that's going to be the number that's used in calculating your tax bills. As I said, it may be lower because of certain benefits you get from having an exemption, having exemptions on the property, like a 10% appraisal cap increase, which prohibits the value from going up more than 10% in a given year, which is especially helpful in those years when property values, as we've seen throughout Harris County in recent years, are rising rapidly in some areas. The market value, however, is going to be that amount that the property would sell to for a willing buyer on the open market. It's HCAD's responsibility for determining that each year. And anytime you get those, and if you can always have the opportunity to appeal the value. If you've got additional information that you can provide HCAD, you have several ways of appealing that value and trying to get that changed. In most instances, that's usually going to mean lowering the value. The next up is, let's talk a little bit about exemptions, because that's kind of pretty important to understand whether you are inheriting property or if you're just a homeowner listening in. So what are they? How do they save you money, and how do you get them? Again, I said HCAD administers those exemptions, and basically they exempt a portion of the property's value from taxation. And those exemptions are used by the local taxing authorities, like the school districts and the Harris County, or the city of Houston, or another municipality that you might live in Harris County. They use those to calculate the property tax bill for that jurisdiction. And it all really depends on where you live in Harris County, what those values are going to be, unless it's a school district. And in school districts, they are required by the state to offer $100,000 property tax exemption for homeowners and in throughout the state. So let's talk about how eligibility is determined and go into that. So some of the most common ones, if you own and live in a resident, that's your primary residence, you of course, no doubt, have the general resident homestead exemption. If you do not, I suggest that you apply for it as soon as possible. There's also one called the over 65 exemption. We're going to get a little bit more into that one, as well as the over 55 surviving spouse. There's also the disability exemption that disabled homeowners can obtain. And then there are certain kinds of disabled veterans exemptions that are available to our members who served in our armed forces, as well as other service type related exemptions, including one where the family, the spouse of a first responder who may be killed in the line of duty, such as a fireman or a policeman, etc., can also receive exemptions on their property. The general resident homestead exemption actually is the one that you would get if you own and occupy the home as your primary residence. In HCAD, that's going to require a little bit of documentation. Obviously, we need proof of ownership, but it's also important that you provide, when applying for that general resident homestead exemption at HCAD, that you provide a driver's license that shows the address where you're requesting the exemption. It must match that of the property. That's when you're going to get that 10% appraisal increase cap. That's where you get the $100,000 school tax exemption by state law, and then any other exemptions that various jurisdictions, taxing authorities might offer in their area. Again, that sort of depends on where you live. The over 65. Now, the over 65 is a continuance of, I guess you would describe it as that of the general resident homestead exemption. It is an additional piece on top of the general resident homestead exemption that you get the year you turn 65. And you do get that for the entire year. So if someone's birthday is December 31st, they would get it for all of 2024. There's also the disability exemption, which is very similar, almost identical to the over 65 exemption that you can qualify for through once you become disabled through Social Security. We would need that information. Or for some people that may be disabled and they don't receive Social Security, they can also get a physician statement that their physician would send to HCAD declaring their exemption. So what are some of the additional benefits of having that over 65 or disability exemption? That includes a school tax ceiling. So those folks that may have had the over 65 exemption, the year that they turn 65, their school taxes were frozen at whatever level they were the year that they turned 65. Now, can they go up? Or can they go down? Yes, they can go down if the value of the property falls. Can they go up? They can if there's some type of major improvement to the home, such as they add square footage by building an extra room, or they put in a swimming pool or a tennis court. That, of course, is going to increase the value of the property, so that freeze would need to be reset. It includes, as I mentioned before, all of the exemptions already granted to the homeowner with the general resident homestead. And it also brings forward the ability for that homeowner to have something called a tax deferral. And they can also pay their taxes in installments without any penalties. There's some other, again, depending on where you live and what part of the county you live in, there are other exemptions that may be granted by various taxing jurisdictions where you are. But it's important to remember that the over 65 exemption is an exemption that gives you a discount off of your current taxes, basically a discount. And it is something that you receive when you turn 65. It is not something that you need to pay back or that your heirs would have to pay back. There is often a lot of misunderstanding between the over 65 exemption and something called the tax deferral, which is an agreement that you can also enter into when you turn over 65 that allows you to defer or postpone those taxes. That in a deferral, you would pay no taxes, or you would not have to, but you're only postponing them. They would be due upon change of ownership. Should you pass away and the person passes away and their relatives or heir would inherit the property, that's when that would become due. But that's the tax deferral. That is not those discounts they were receiving because they had an over 65 exemption. And I want to stress that because I've run into time and time again seniors who are afraid to apply for the over 65 exemption because, as Lisa kind of mentioned earlier, they may have been listening to some street lawyer who said, oh, you're going to have to pay that back, or your kids are going to have to pay it back. And that's not true with the over 65 exemption. That has more to do with a tax deferral. And that's an additional option people can enter into. But please remember, when they have that over 65 exemption, that is something that they have. Now, once another person inherits or takes over the property, they may not be eligible for that over 65. They won't be. They would have, even if they were over 65, they would need to refile because the property has changed ownership. The over 55 surviving spouse exemption, that simply helps protect the surviving spouse should the owner who the couple was receiving the over 65 exemption from happens to pass away. Remember, I mentioned there's going to be a change in ownership, but if their surviving spouse is at least age 55 years or older, they would be able to maintain and receive all of those over 65 exemption benefits that they were already receiving. Nothing has to be reset. It doesn't have to be changed. You simply need to let HCAT know. The school tax ceiling that we talked about they'll be able to continue that. And again, they will be eligible for the tax deferral and pay taxes in installments with no penalties. Another important piece of information for a lot of folks that may be out there living in a home where there are other heirs that also are entitled to a portion of the property, a percentage of it. There is, because there is a particular way that a single individual can receive those exemptions that I talked to you about that previously they may not have been eligible for because they did not own 100% of the property. And for this, when you fill out it, you can find this section on our exemption application at HCAT on our website. And there is a section 3 of it, the homestead exemption application, where it's going to ask you the question. It asks the question, is the property for which this application submitted an heir property? And if you say yes, it's going to ask if other heirs also occupy the property. And then there is a process of some additional information you would have to provide in order for you to get the exemption which allows you as the person living in the property paying the bills, to be able to get that exemption at 100%. It does not, and this is important to remember, affect the ownership rights of any of the other heirs. It simply allows you, as a person living in the home, with the consent of the other heirs, who may be living in the home, to receive that 100% exemption, to save you the same type of money that people who own their homes 100% would receive. So that's an important one, particularly for people who are trying to maintain family property. So there's another one called the immediate resident homestead exemption, and I'll just bring this up on just very quickly, where individuals who move into a home for that first year and the home had the previous owner did not have any exemptions attached to the property, they can begin receiving that homestead exemption at a prorated rate. So if they move in April, then they can continue to get the exemption, which will be prorated for 8 months of the year as opposed to the full year. If the home was previously owned and was already receiving the exemptions, then you'll still be able to benefit from those exemptions until the end of that year. So you would be able to get that previous owner's exemptions for the rest of the year. It's important to remember, however, if you are applying for that immediate resident homestead exemption because you just moved into the property and there were no exemptions on it, you need to file that before the first anniversary of the date that you acquired the property. Otherwise, you won't be eligible for it. So how do you get these exemptions? We try to make it pretty simple here at HCAT. There's a paper form you can request that you can mail in. There are online forms that are fillable online. There is a mobile app that you can go out and apply for the exemptions that you can download through either Apple or Android, or you can simply email that information in using one of our forms. The online application that I mentioned second also comes with, on our website at www.hcad.org under forms, also comes with a video that will basically walk you step by step through filling out that form and reminding and informing you of what else you need to send in along with the form. And it's important to send it in all at once so that your application is not delayed. So there's also a form on our website that says a request to remove the homestead exemption. So in the event you are inheriting property and moving in, and it may not be that you're going to, maybe you're renting it out, or maybe you are not eligible for the over 65 exemption. There's some things there are forms that you can fill out at our website for that as well. Keep in mind, we may require some documentation if you're requesting it, including proof of ownership, or in some cases, if you're moving in, we will require a copy of your driver's license that matches the address on the property. So this is important for folks to. It's kind of an annual reminder. In addition to the valuation letter that HCAT sends out each year to homeowners, usually in late December, early January, you'll get a card in the mail from HCAT. And basically, it's a card that is confirming what the exemptions are on the property. If you get this in the mail and nothing has changed, then fine, you're free to throw it in a drawer. If you get this in the mail at a home and you know things have changed, this is kind of a reminder for you to contact HCAT and say, hey, I need to change my exemptions information with the district so that I am paying for correctly. I'm being billed correctly for my property taxes. Keep in mind that if in fact the property changes hands and exemptions, and the new owner is no longer eligible to receive those exemptions, the property tax law in Texas allows the jurisdictions to go back at least 5 years to collect any taxes owed that you did not pay. So it's really important to make sure that you keep that information, that you keep your exemptions information up to date. Also, this is what our website at HCAD looks like. We're at www.hcad.org, and I think I mentioned earlier, if you look under that second blue line, you see property search. If you want to go out and check if I've introduced any doubt in your mind, you want to go back out, you want to go out and check whether your exemptions are correct, you can actually go out on that site and look at the and type in your information, pull up your property, and it's going to say whether you have a residential homestead exemption, or if you have an over 65 or disabled homestead exemption. It's not going to say that because that gives a little too much personal information about the owner living there. It's going to say multiple, and you'll know if it says multiple, you've got that additional exemption that you either over 65 or disabled. So it's good to check every now and then anyway. We do recommend that. And also you go under forms and you can pull out all of the forms, any of the forms that you need to send in, many of which are fillable online as well. So I do want to quickly remind you before I go, for anyone who may have been affected by Hurricane Beryl, there is something called a temporary disaster exemption that is based on the disaster declaration following Beryl. And it allows you to, gives you some tax relief based on the damage that was done to your home. It has to be at least 15% damage is the threshold, 15% of your valuation. And you can get that, you can get some relief for this year for that. The deadline to apply for that, however, is approaching. It will be October 21st. It's always whenever there's a disaster in Texas, and the governor declares it as so, you always have 105 days to file that temporary disaster exemption. If you're not sure, go ahead and file it anyway, just to make sure you got it in, and that can all be sorted out later. But remember, the deadline is October 21st. And again, here's where you can contact us. We're located, our building is out here on the Northwest Freeway at the Hollister-Tidwell exit. Our general phone number, as you can see, 713-957-7800. You may have a little bit of a wait, but you can also leave your number and they will call you back. The website is, of course, hcad.org. And then you can also send in your information inquiries through our online process, which is https://hcad.org/contact us. And as you can see, form, and that gives you the opportunity to kind of fill it in and send it in, and someone will get back with you through email, or in some cases, they may even call you. And that is pretty much my presentation for this afternoon. Thank you so much for listening. And I will be hanging around along with my colleague Rosalind till the end of the presentation to answer any of your questions. Thank you so much. And now I will turn it over to Jamie.
Hello, thank you, Mabel.
Welcome.
Hey, Jamie.
Okay, so there we go. It's good seeing everybody.
Likewise.
Okay, let's see. Let's get this started. Lot to cover, lots of ground to cover. Okay, so let me see.
While you're pulling that up, Jamie, do you want to just tell everybody who you are? And
Yes. Okay. Okay, here we go. So good afternoon, everyone. Thank you so much for making the time to be out here today. My name is Jamie Duong. I'm the Director of Property Tax with the Harris County Tax Office. We're here on behalf of Ms. Ann Harris Bennett, your Harris County Tax Assessor Collector. And with me in the chat room today is Shay Pinkowski. She's going to be helping answer your chat questions and also assisting with this presentation as well too. Now, a lot of things were covered by Lisa and Mabel through their presentation, and hopefully our presentation here will help to wrap all of this together as far as how what the impact of receiving ownership of a loved one's property, or just planning your own estate, and how does taxes and exemptions and having the right will or the right documentation and process really impacts you. Because if you think about it, if you're in the planning stage of this, you got to do it right, because I don't know how you can redo it after you leave. So without further ado, let's try to get this started, and at the end of that we will have the question answered, the question portion, so that we can address any of the concerns that you may have. Okay, so everyone sees this now? Yes?
Yes.
All right, so again, on behalf of your Harris County Tax Assessor Collector, Ms. Ann Harris Bennett, we welcome you to this workshop. Our goal is to provide you with information and resources to make good judgment, or to make good decisions. And if nothing else, at least to let you know that there are more additional information, or there are other things out there that you need to question and ask in the planning of your estate, in maximizing your benefits in your own home ownership. Okay, so what do we do? The Harris County Property Tax Division represents over 1.6 million property tax accounts, and these range from your residential properties to your business properties. And through that, we collect a little bit over $8 billion in property tax annually. And from that money, $8 billion, we distribute that to a little bit about 80 taxing units throughout Harris County. Now, this includes your Houston Independent School District, your City of Houston, or the Flood Control District. Okay. Okay, now how is your tax bill calculated? Well, right now we are at the very middle part of that. Okay, so first of all, earlier Mabel had mentioned how the appraisal district plays into your property ownership. So usually around beginning of the year to about May, June or so, is where the protest process happens, or any corrections or any changes and stuff. So once your value has been settled, whether between the appraisal district and the property owner, or through other resources and means, once the property value has been settled, and if there are exemptions that you qualify for and you file for those exemptions, then the appraisal district certifies the value to the tax office. Now, currently they've done that already, and right now we're in the middle of this, where it is the truth and taxation phase, where your local taxing governing bodies are determining what should be the tax rate, the necessary tax rates in order to maintain the services for the taxing units. Now, part of this truth and taxation is conducting hearings and having public notices and engaging with the public. So as of last Tuesday, and even you're hearing some of this blips on the radio or TV now, is that, the City of Houston's talking about property tax. Okay. Harris County is talking about property tax. Flood Control District is talking about, increasing property tax rates to help meet the disasters and the necessities of fundings for some of these events, the disaster events that have happened recently, or prepare for the future. So on behalf of Ms. Ann Harris Bennett's office, we encouraged you to participate in this process. check online. When are these hearings, or what are the information related to this? Participate in the process, ask the questions, because this is when they decide what the tax rate it would be. On the first part of it is how much is your property worth? You decide that part of it. How much should your property be worth, or how much should it be appraised at? That's the first part. The second part is the tax rates. Now, this is where we are right now. Now, once the tax rate has been voted and settled on, then certified by the governing body, then the last part is the tax bill. This is where the tax office comes in. Now, usually people complain about, well, my tax bill is too high. Well, if you wait for this last process, really, there's not too much you can do, because where we are right now, this is is where the rates have been is being settled. So so for us, we come back to tax bill equals taxable value multiplied by tax rate, applies any applicable exemptions, whether it be a homestead exemptions or what have you. Then we generate the tax bill and we send it to the property owners. Now, there were some recent changes made to the property tax code that may impact how much you pay in taxes. For example, for Harris County, the exemption amount for properties that are owned by property owners over 65 years of age, or disabled veterans or surviving spouses, 55 years old surviving spouses, the exemption amount for Harris County goes from $250,000 to $275,000. And of course, for 2024 tax year, which is this upcoming tax bill, that $275,000 is going to be increased to $320,000. Okay, so this is the amount that will be exempt from taxes. Yes, for your Harris County taxes. Yes, that's true. 320. Now, the city of Houston did something similar, but not that amount. So the city of Houston, again, for ownership, property ownership, for over 65 years of age, disabled veterans, or 55 years surviving spouse property owners, the exemption amount goes from $160,000 to $260,000. Okay, and the school, of course, Mabel had mentioned earlier, the general homestead, that goes from 25,000 to 100,000. Okay, so all of these comes into effect, essentially means your tax bill may be lower. Okay, of course, we've also mentioned that the new property owners are eligible to apply for prorations for partial homestead if they owned the property during that course of the time. So partial homestead exemptions, okay? And also something else, let's see, we talked about, and also for businesses, or for non-residential properties, there is a limit to the increases in property valuations for properties that are under $5 million, okay? That is non-residential, non-homestead, okay? And of course, through all of this, last year we had a requirement for restructuring the school finances. That's continuing on. Now, as we approach toward the end of the year, you're going to be seeing your tax bill. Usually for this year, the tax bill will go out by the first, if not by the second week of November, because there will be tax rate elections, and we have to wait for the elections to complete to get your bills calculated. Okay, but when you get your tax bill, several things you need to do. Take a look, make sure the exemptions are there, make sure the information is correct. Make sure that that you see the valuations that's there. Okay, confirm that. Go online to check it. Now, earlier we talked about exemptions and what are their benefits. I believe in a picture is worth 1,000 words. This is an example of an average property in Houston with the appraisal value of $325,000. If there were no exemptions on the property, your tax bill, the tax bill that you're looking at would probably be about a little bit over $7,000. Now, if this property, same property valuations in Harris County and in Houston, if if you have a general homestead exemption on this property, you're looking at a saving of some $1,800 just because of that general homestead exemptions. And because if that's your primary residence. Okay, we move on a little bit further. If this is your primary residence and you're an over 65 owner, or you have a disability, or you're able to qualify for the disability exemptions, or the surviving spouse exemptions, or a veteran's disability exemptions, then your original $7,000 tax bill now becomes just a little bit over $2,000. So the benefit is there to make sure that if you qualify for any of these exemptions, apply for it. Okay, you must apply in the first year for these exemptions. Okay, now something else of a tax benefit for property owners that are over 65, disabled veterans, or surviving spouses of anyone in that category. Once you file that's exemptions, that's over 65 exemptions, your property goes in what is known as a tax limitation. So it limits the taxes on the school tax, okay, on the school portion of your tax bill. Okay, now this applies only if you have that over 65 coding on your property. Okay, so make sure, very important, to follow through the process to get the required documentations into the appraisal district to get that qualify, so that you can reap benefit of that tax limitations. Now, another benefit of having that over 65 exemptions or on your account, if you're over 65 or disabled veterans or surviving spouses, if anyone in that category that's over 55 years of age, is you may qualify for a tax deferral. And the way that I've explained tax deferral is that a tax deferral is like an insurance. It's there if you need it, and if you don't need it, it's there, but it doesn't cost you anything. Okay, it doesn't cost you anything in the terms of say, well, if I want a tax deferral, what does it cost me? Well, here's what the tax deferral does. The tax deferral postpones your tax. It's very important you understand that a tax deferral does not eliminate your tax, or does it cancel out your tax. It merely postpones your taxes, and it basically says, hey, well, we understand we have a tax bill that's due. I'm not paying it. I'm choosing not to pay on it. So what you have is, there's a coding on the property. If you qualify for it, we put a code on that, and that unpaid balance will only accrue a 5% interest. Okay, will accrue a 5% interest only, as opposed to a property that doesn't have the deferral on it. It would continue to accrue the escalating penalties and interest on the account. For example, if the taxes for a general property homestead, or just general properties, if the taxes were not paid by February the 1st, which is the first day of delinquency, you have an automatic 7% penalty on that. However, for a deferral account, it's only 5% for the entire year. Okay, so you see the benefit on that. Now, one caution to think about: if there is an outstanding mortgage on the account, please make sure you consult with your mortgage company before you file your deferral request. Okay, very important. Make sure you talk with the mortgage company. Make sure that it's okay with them. Now, how do you go about getting a tax deferral? Well, there's an affidavit on the HCAD website. Download the affidavit. You can complete it online and then get it notarized and send it to the appraisal district with the required documentations to get that on the system. Okay, now what happens if you don't qualify for the over 65 and you don't have the deferral, and it's just you have the taxes? What do? You need time to pay. Well, don't worry, we can help you with this. The tax office have payment plans that goes from 12 months all the way to 36 months. Okay, and you can start requesting for the payment plan as early as February the 1st. Now, what is the purpose of the payment plan? The purpose of having a payment plan on the account is to help you avoid the attorney fees. Okay, it helps you avoid attorney's fees, and it helps you avoid any foreclosure actions as long as you keep in performance with the payment plan. Okay, so it's very important. Just reach out to us and say, hey guys, I owe 6 months of taxes, or I owe 2 years of taxes. What kind of payment plan can you do? And we'll be happy to walk you through the process. Now, if you're folks, if you have back taxes and you're over 65 or you're disabled veterans, or, you know, surviving spouses of anyone in that category, you may qualify for a quarterly payment plan. And the quarterly payment plan has no interest assessed on that, as long as you pay by, you know, by each of the four quarters that's designated. For example, end of January, end of March, end of May, end of July. Okay, but very important, to qualify for that quarterly plan, your account must be approved for the exemption, must be approved for the over 65 exemption, must be approved for the disability exemptions, must be approved for the disabled veterans or the surviving spouse exemption. It must already been coded and approved by the appraisal district. Okay. Now, for everyone else, what other payment plans do you guys have? Well, we have the homestead plan. Okay, and we also have the generic plan, which all of these takes into account the current tax year and any prior tax year that you have. Again, reach out to our office. We'll walk you through the process. And again, the importance of having a payment plan is that it helps you avoid attorney's fees. It helps you minimize, if not reduce, if not limits the amount of fees and penalties that you have to pay. Okay, now to make a payment, what kind of options do you have? The easiest, go online at www.hctax.net. Okay, you can pay by mail. Of course, if you're sending in it by mail, we always tell our folks, do not wait to the last day or the day before the last day to drop that payment into the mailbox, because if it does not get postmarked before February the 1st, your account may be penalized with 7% penalty. Okay, so it's very important. And if you're waiting till January 31st to pay your bill, then the best bet probably is to go to the post office and get that postmark on there, stamped on there. Okay, another easy way to make a payment, you can pay by phone by calling 713-274-2273. And, you know, key in your account number, and the prompt will walk you through the process of making the payment by phone. Now, if you're paying online or by phone or by mail, you can make, of course, check payments. Okay, online or phone, you can do credit card payments, which has a convenience fee that the bank assess of 2.45%. Or if you prefer to pay by e-check, there's no fee to that. It's free. Of course, if you are paying cash, you need to be in person at a branch. Do not mail cash into the tax office. It's very important. Do not mail cash into the tax office. Now, as we are approaching, okay, let's see, what does it do? Oh, as we are approaching, let me see what, okay. Okay, so as we are approaching the tax year, you know, we encourage our audience and we encourage you, our neighbors, to keep in tune to the developments right now that's going on, whether it be at the government level, whether it be at the commissioner's level, at the city council level, to see how you can get involved in understanding what is going on in shaping your tax rates or property tax bill. Of course, if you have questions, reach out to us. You know, we are online at www.hctax.net. You can also email to us at tax.office@hctx.net, or you can call us at 713-274-8000. Again, we thank you for your time and we appreciate you being here. Thank you.
Okay. There was a question that was posted here in the chat. It says, I have the original deed of my property in my parents' name. My father died in 1983. There is no deed in my mother's name. My mother died in 1982. An affidavit was filed stating that I am the heir to the property. I don't have a deed in my name. What do I need to do to get the deed in my name, or do I need a deed in my name?
You do not, I'm assuming this was an affidavit of heirship and you don't need a deed. That's sufficient notice in the property records.
Okay, so if the mother died in 82, the father died in 83. Okay, so once you have an affidavit of heirship on file, you don't need a new deed to be issued?
No, I've never heard of anyone getting a new deed. I don't know if a title company does that, but when I did prepared affidavits of heirship, that was sufficient. And I know at least probably 2/3 of the people I did affidavits of heirship needed them to apply for the county repair programs or to have their houses rebuilt. And that was sufficient for the county programs.
Okay. Let's see. There were a few that were emailed to me prior to.
I got a private question
Okay, go
that
ahead.
I thought was really good. I thought it was a great question. They asked if the property has to be fully paid off to have a transfer on death deed, and it absolutely does not. What you are conveying is your interest in the property. And if there is a loan or any type of mortgage on a house, that stays with the land. So the heirs would be responsible for paying whatever was owed on either a home improvement loan or a mortgage.
When they file a transfer on death deed, though, does that still then become sufficient for the mortgage company to talk to them about the
It
balance
should.
on the account? Or
It should. I've never run into a problem with that. I can't say 100%, but it should be sufficient.
okay. Let's see. My aunt died in 2011 without a will for her property in Corsicana, and the taxes were paid by me through 2017. How can I then inherit the land?
You need to do an affidavit of heirship. And if there's any other family members that are also entitled, they would need to sign their rights over to you.
Okay. What is the role of the title company when using an affidavit of heirship?
I think every time that I've done an affidavit of heirship, no, I've done it when they were selling the property also. You need to talk to a title company to make sure that the affidavit of heirship is fine. If you are planning on selling this property that you've inherited, talk to the title company or have your realtor talk to a title company and see what the title company wants you to do. Because sometimes the title company themselves, I had a situation where the title company actually prepared an affidavit of heirship.
Okay. Let's see. Okay, oh, that was the question that was just asked already. How does one proceed? Oh, I hear talking. Is somebody asking a question or is that background noise?
I thought I heard something too, but I don't hear it now.
Oh, okay. Let's see. How does one proceed with intestate probate if the estranged heir cannot be located? If an estranged heir cannot be located?
You could still proceed. I have had situations like that. You still proceed with probate. The judge will most likely require a dependent administration because legally they're responsible for protecting everybody's rights. And a dependent administration means that you will have to have a bond, and usually I think it's 10% of the estate value. I haven't done this in a long time, so I may be off, but roughly that's about what it is.
Okay, how do I transfer property into someone else's name if I'm the executor and the person to transfer the property to inherit it?
Your attorney will make sure that your attorney prepares an executor's deed. And the executor's deed is a deed where the executor of the estate transfers the property to whoever it's supposed to inherit. And this is something I learned just the other day. A client asked me this question. She had inherited a house through a will, and her attorney never prepared an executor's deed. So the property still was not legally hers.
So with an executor's deed, you don't necessarily have to be like does that mean you're not the relative or the
It's
immediate
the person named as the
heir?
executor in the will.
But the heir
So
can be the beneficiary.
And the heir can be the beneficiary, but the executor has to sign the deed.
Oh,
Basically, the executor signs a deed saying, I, as the executor of Miss Smith's estate, transfer the property to whoever it is named in the will.
okay. Let's see. My mother passed without a will. My family has mutually decided to whom should inherit it. Who should inherit her property? Is there a way to accomplish this without going to probate? And there's like 3 parts to this question. So that's the first part of the question.
Yes,
So
that's
way
where
to-
a great example of doing an affidavit of heirship. You would need to do 2 steps. You would need to do the affidavit of heirship, and it would be transferred to everybody who's alive. Then the people who don't want to have the house would sign a deed giving their share of the property to the person who's going to have it. For instance, all the time with houses, I would prepare an affidavit of heirship, and the children had all decided that this one brother is going to inherit the house. So I prepared an affidavit of heirship that gave the property to all the children, and then 4 of the children signed a deed transferring their share to that brother so that he owned it 100%.
Okay. Next part to this question, how does MERP affect this decision?
If it happens outside of probate, MERP does not apply. And for people in the audience, MERP is Medicaid estate recovery. And if you probate somebody's estate, they can recover whatever they spent on your loved one for nursing home care. But if you transfer through a transfer on death deed or affidavit of heirship, MERP does not apply.
Because it doesn't pass through probate.
Right, MERP only applies when it passes through probate.
Okay. And what happens if the property taxes were deferred on this same property?
That would be a Jamie or Mabel question.
What happened if the property is deferred?
Yeah, when they're doing the affidavit of heirship and they're inheriting property.
Deferred properties.
Mm.
Okay,
Yeah.
so it would read as if there's a change in ownership. Okay, but first it would check to see if the change in ownership. And then you would also have the option of applying for the exemptions, the homestead exemptions. Okay, but these back taxes come back and you can reach out to us and say, hey, do we set up a payment plan to handle these deferred taxes?
Because the taxes stay with the property regardless of whatever one of them inherits.
Yes,
Right.
Somebody
Yes.
still owes all the deferred taxes.
Right.
correct. Somebody owes the taxes. The question is, how do we handle the outstanding tax bill? And that's why, as Mabel and Lisa had mentioned earlier, someone passed away, do not try to hide that says, oh, it's been 3 years. The longer I push it off, the more benefit I get. No, they will come back and they will tax you and they will add a penalty to your account. But by the time the 2 year, 5 years that you think you got away with it, guess what? Your 180 days grace period completely vanished. Because, for example, if someone passed away, toward January and you got the tax bill and it's like, oh my gosh, well, by law, if there's a deferral on that account, that for that property owner, then that account has 180 days where anyone can pay back the taxes at the same rate as that deferred owner. Okay, so you can pay back if, as I've mentioned in my presentation, the tax rate for deferred tax is 5%. You can pay back 5% for, 6 years of taxes or whatever it is. But if you wait 3 years and 4 years, hoping you get away further, guess what? By the time the 3 years, 4 years come back, that 880 days has been gone. And guess what? Now that tax has all of the full penalty and interest assessed. Okay, and attorney's fees itself is at least 15%. And it
Okay.
compounds.
In
So
other words,
it's a sucker punch.
What'd you say, Miss Mabel?
In other words, you're being charged at the full delinquent rate after 100
Yes.
days.
Yes. And then you were crafty and smart for 3 years for not reporting it. Yes, guess what? That crafty 3 years come back and compounds.
So for
That's-
somebody that's not a devil's advocate here, from not trying to be crafty. So when someone just assumes I am the child or I am the spouse, that parent or whomever had an exemption, or I'm the next heir, didn't think that they're supposed to actually probate anything or do anything, that they think that they're just automatically inherit.
Mhm.
In that regards, the penalty and everything still applies regardless if they knew or didn't know.
Well, unfortunately, one of my left, I do is legislative analysis, and I comb through that tax code for the last over 10 years. And there are only 3 small exceptions to where they would waive the interest on that. And that's only if the government entity did anything wrong. Okay. So the part of omission, the part of not knowing, even the part of not getting your tax bill does not waive your penalties or waive your taxes due. And something I always put reminder, and today I forgot, when we talk about deferral, is if you apply for a tax deferral, as much of it as a benefit to you, do yourself and do your heirs a favor. Put a note in your will that says, hey guys, or even print out a copy of the tax statement, says, hey guys, here's the tax bill, because the tax statement will have an account number and will have a year, and it'll say tax deferred on it. Okay. And attach that with part of your will so that your heirs or whoever comes and probate that, or your executor, will know, all right, we need to contact the tax office and the appraisal district to notify them, to update the information and then give us an estimate of how much is owed on taxes.
Or even I'd say for those folks that have those parents and grandparents or aunts and uncles that are prideful, and you have no clue as to what kind of deferrals or what kind of financial situations they be in. Be nosy,
Yeah.
look it up and see who actually has a tax bill, or who's been paying a tax or who hasn't been paying a tax, just to make sure that it's gotten paid, because otherwise you don't want to be caught off guard not knowing, what's going on with that tax bill for that parent or grandparent or whomever. There's another question here. Is it possible to use adverse possession against other potential heirs, parents primarily responsible for heir property in which they had an interest, other heirs never granted permission for parent to manage heir property?
You need to talk to an attorney to make sure you meet all of the elements of the statute, but it would be possible. I don't know enough about their situation to give an exact answer, but it is possible.
And
Yeah.
and I want to add something to that side of it. Any tax payment you made is a voluntary payment. So if your attempt to go through adverse possession fails, you cannot come back to the tax office and ask for that money back. We will not give it back.
Thank you.
That brings me to my next question or point, Jamie, and I have to
Sorry.
bring this up every single time when you get people that are on the internet, Facebook, Instagram, telling you how we can come to this meeting and we can show you how to get property that's has back taxes and deferred property taxes due. How does that work in Harris County in Texas, period? If you've got somebody that's got back taxes that's owed because it's an heir's property that's been deferred, and then I
So
come in,
I'm gonna
down
do a Jane from the street side of this.
okay.
Be Jane from the street. Okay. You're sitting there. I actually saw this YouTube ad that says you can own the property buying the tax certificates. I actually saw this. You saw this, okay? And you go to these, what is it? They have 6, 8, 10, 12 workshops for the weekend, Sugarland, Marriott here, whatever. I don't care. It's okay. So not as a tax professional, not as somebody who deals with real estate or whatever for
In Texas.
for a while. In Texas, yes. So I'm gonna tell you this, the very basics of this is Texas is not a tax certificate state. You don't own the property by buying the tax certificates. Okay. You do not. The only way you own the property is if somebody sells it to you. And if they sell it to you, it either has to be out in the market or somebody trades that. And if the government is selling it to you, it has to be on a foreclosure. It has to be on a tax sale. Okay. So, but if somebody's telling you, hey, pay us $300. We're going to teach you how to own this, you know, because look, here's this tax certificate. It has $1,200 in taxes owed. And you pay $1,200 in taxes, you own this land that's worth $15,000. Well, you know what? Congratulations, you've donated $300 to somebody. Okay, I'll just be very honest, because if the basics of the law in Texas, we're not Oklahoma, we're not other states where they honor and they have their restrictions on tax certificates, property ownership, but in Texas, the underlining does not match. Of course, I'm not a lawyer, but as an investor, as a real estate person, and as a property tax person, I can tell you, you giving me a tax certificate does not equate to you giving me the property. So if you're
Jamie,
willing.
I'm so glad you brought that up, because that's 100% correct. I've had clients that assume that they now own their mother's house because they've been paying the taxes on it. I can walk off the street and pay any one of your property taxes. I'm not going to ever get
Exactly.
that money back. And HCAT does not give me any right to the property.
And you know what? One of the first thing I learned at the tax office was, and I was literally slapped upside down, because they say you do not refuse payment from anybody.
That's amazing.
As a tax, you know, I mean, and they're like, you are a tax assessor collector. You're an agent of the elected official tax assessor collector. You do not refuse tax payment from anybody, even if you don't know where to put that money to. Yes, yes. So it's short of being written in law. So that's what I'm saying. In the previous questions where it was asking about, hey, can I pay somebody, even if there's, you know, brothers and sisters and one want to take adverse possession against the other and paying the taxes, guess what? When that stunt ends and you don't get the property, I'm sorry, I'm not giving you back that money, because guess what? Not because I'm being mean or whatever, because the law will not allow me to refund any voluntary payment that you've made. So I hope it answers the question.
Yes, in relation to the adverse possession, is it possible to get a full accounting of all taxes paid from, I assume it means the tax, they said HCAT, but from the tax office?
You would have to do an open record, and you would have to pay for a research fee, because that goes for a very, very long time. Now, there's information available on our website that it goes as far as it has a tax amount for 5 years, that we have a 5-year tax bill on that. But that shows you how much taxes is owed. But if you want to know who paid and how much and what have you, you would have to do an open records on that, and they have a fee that they charge on that.
How far back does that go versus the 5
It
years?
varies. It varies because I know when I first started here, we had a lawyer that was really a contested case, and the lawyer was willing to pay for, you know, I tell them, look, the rate back then was $50 an hour for research, and he was willing to pay for that research. The estate was quite substantial, so we had to go all the way back to 1980 plus, and part of that was the payment was on microfiche. So we had to
go through the film and look at, oh, wow.
Yes. And part of that stuff was in archive in another building and what have you. So, you know, having to go and get all that, hey, if you're willing to pay for it, we'll do our best to get what's there.
Okay. So basically request a time period, not necessarily in perpetuity.
Yeah.
Okay.
And just don't do broad, hey, I want to know who paid this and what was paid. More than likely they'll reject your request. You know, say for a specific reason, tell them, hey, I'm trying to do this. I need the payment record for X year, Y year. And at least we know to hone it in to say, okay, you're not wasting a lot of research time. How much does it really cost you? You know, our goal is to be efficient and to be helpful, regardless of what purpose you're using the information.
Gotcha. All right. Another question here. Is it easier to put a property in a trust and put the children as beneficiaries?
Don't put your property in a trust. Somebody did PR for trusts, and it is, everyone in the world thinks they need to have a trust. That is
That's the world of social media. Everybody thinks that everything applies to the state of Texas. It's not.
Everything that I'm telling you here is only in the state of Texas. I can't speak to any other state, but the only times you really need a trust is if you have minor children, if you have an adult child that gets some type of disability benefits, and you don't want them to lose their benefits, or if you are a billionaire and you want your estate to be private. The owner of the Texans, when he died, everything was in a trust. That way it wasn't public record. I can understand that. But for us regular people, we don't need to be that fancy. It is complicated. If you put your house in a trust, it is harder to get your property tax exemptions and deferrals. Also, one day you might want to sell that house. You'll have to go through the process of hiring an attorney to take the house out of the trust, transferring it back to you. And it's a lot more complicated than it's worth.
And a lot more expensive than just.
And a lot more, trusts are
You
incredibly
just trying
expensive.
not to go avoid probate. It's more expensive.
You will easily could spend $15,000 on getting a trust. And your probate should never cost that much unless everybody in your family is fighting.
Wow. So that answers that last question that came to me. How do we get the name on a property that's in Louisiana? So that was all I had.
Just wanted to, one thing I wanted to mention before we jump off too is that we recently sent out a press release regarding, this is HCAT, a press release regarding the Appraisal Review Board, and that it is now open and accepting applications for the 2025 year. So if anyone is interested in perhaps being a member of the Appraisal Review Board, which is a peer group that reviews and hears protests from homeowners, they can apply at they can find the application on our website at www.hcad.org.
Thank you very much, Miss Mabel. Miss Lisa, I did have one more question that
Sure.
kind of came to mind, and you find this a lot. It happens with a lot of heirs property when there's multiple heirs and so on and so forth. If you've got a property that's been inherited that was maybe grandparents' property, and then you've got children or somebody that's fighting over it, if you've got one person that wants to force the sale to an investor, is that possible? And two, what do the other heirs need to do to prevent that from happening?
That I'm really glad you asked this. This is something really important to think about, because a lot of people think, I want my house to go to all my kids. You know, that's a lot more complicated, because if one of the heirs wants to sell it, they can go to court and do what's called a partition suit, and the judge will force the sale.
Mhm.
How you can prevent it is only giving your property to one person instead of a group of people.
I want to jump in this on the tax side of it. Imagine you're writing your will right now, okay? And I don't care if it's 2 years from now or 20 years from now that the property actually goes to your heirs, okay? Now imagine after that 20 years where the property goes to your heir, there's going to be several more years of haggling. Who's going to pay that property taxes during those years? And I won't be too nice to say that, you know, having two names on that, you know, I love both of my children equally, is the most brutal things you can do for them. Because more than
Absolutely.
likely, in a way or not, that tax will not be paid equally. And that tax, if it's not paid timely, that becomes an absolute burden.
You
That
always
is
get that.
really
I
important.
don't live there. I don't, so and so should be paying the taxes, but if you sell it, I want my equal share, even though
Oh, you didn't give me
been
the
paying
tax bill. You didn't give me
Yeah.
the tax bill. I'm not paying it. Just because you send it to Johnny doesn't mean I have to pay it. Well, he promised me he was going to go down there. He was going to go down there and pay it. We hear this so much, and you know what? Our heart breaks. Our heart breaks because I'm pretty sure the parents or whoever left that property did not intend for it to tear up the family like this.
Yep.
You know, that is such a great point, because you don't want to hurt anybody's feelings or make one person think that you didn't love them as much as the other. That's going to create a battle in the family down the road. It will. It always does. It's much better to be open about it, because, you know, at Earl Carl, I would run into so many situations where we would do an affidavit of heirship to transfer the property, but only one of the family members lived in the property. That one family member ends up being responsible for the property taxes, the upkeep, you know, any loans on the house. But the siblings refuse to sign it over. They don't want to give they don't want to pay anything, but they're not going to give it up. And it leads to some pretty ugly battles. And then there's that one person that's been stuck with paying all the bills.
And
You know,
the end of it is even, when we send our tax bill around December or January or October, that means whoever's is the mature party, okay, or whoever is the one living in the property right now, the burden is on them, to go around to all the heirs, try to gather up enough of that funds prorated or, proportionate to pay for the taxes. And you pray that by the January 31st, that taxes is paid on time. Or if there's a late fees, now you have to bring your face back to all the heirs and all the siblings and saying, hey, there was a 7% fees on that, and justify that payment. And like I say, it does not sound too kind to nice to say, pick a child and put that name on that person's child, that property on that one child, to make it that responsibility to that person.
Myra used to say, once you're dead and gone, who cares if they're mad at you for whatever, but you're not going to be there to take the brunt of it anyway at that point, but at least your kids aren't fighting over it. At least, it's not potential for being lost to an investor or a foreclosure tax sale or somebody just losing it all together or just walking away from it out of spite because they don't want one to have it over the other. We have seen so many different scenarios after doing all of these workshops since 2017, 2018, so many different stories that have come up to us for people just not having things written down, not having things in order, and people losing out on wealth, and just kind of giving it up and out of grief, out of sheer grief, out of sheer greed. And at the end of the day, whatever it is that the parent or the grandparent or whomever decides, it's their property. They can do with whatever it is that they want to do to it because they paid for it. If they want to give it to the neighbor, it is not yours. You are not entitled to it because you didn't pay for it. So however it is that they choose to do whatever it is that they chose to do with it, just honor whatever it is that they wanted to do. It's just, but think about it. If have the conversations with your family members, find out, what is their intention. Get everybody on the same page so that everybody can talk about it and everybody knows. So then there is no conflict at the end because nobody ever had the conversation about it. Nobody likes to talk about the end of life care or, what happens after the loved one has passed or, and then people kind of get up when they're in the midst of planning a funeral, they want to try and deal with this kind of stuff while they're grieving. Take the grief off the table, take the time to grieve, and let everything just kind of die down before you kind of dive into what's going to happen to Big Mama's house, who's going to pay the taxes, who's going to pay the bill, who's going to do this and who's going to do that. Just take the moment to grieve and kind of deal with the feelings and then take the feeling out of it and then handle the business like it needs to be handled. Because otherwise, the property, you have a little bit of time before the property actually goes anywhere. You don't have to make a decision about anything the day somebody passes away or the day after they pass away or what have you, but at least start having the conversations with people and get the family talking. I mean, even if you just kind of bring it up in passing, because we still got those parents that don't want to talk about it. They think it's a jinx for you to sit and talk about what happens after you're gone or what you want your burial to be like or whatever. But we've seen so many folks fight over sheets, over shoes, over earrings, and so many people have always
We
said,
got a division on forks, on the forks.
My family gets along. We all, we all love each other. You just wait until somebody passes away and wait until and let the claws come out because everybody grieves differently. Everybody,
and the claws will come out no
and the
matter
claws
what.
will come out regardless of how well you think your family members get along. Somebody is going to be a little spiteful or the true feelings come out. She liked you better than she liked me, or or did more for you than she did for me, or whatever, or that long lost child that comes out of the woodworks that nobody knew about. ta-da, you know, comes out of the blue. Or you find out that your parents were never really married in the first place, but he was still married to another lady that lived in California. We actually had that happen. That the parents, long story short, parents married, been together a long time. Kids never knew that the father was still married to another lady that lived in California. She came back to town and told the funeral and made the arrangements that she wanted to make and decided to have him cremated because she was still legally married to this man and decided what to do with his body. And the family had nothing
You have to do it.
about it.
I had a sad situation where I did a will for a gentleman, and he was somebody that if he just met you on the street, he would tell you that he grew up in foster homes and that no one who he was related to cared for him at all. And his family was his wife's family, and he wanted his niece and nephew to inherit everything. We did his will, and he lost it. And when his in-laws found him dead in his apartment, they couldn't find the will anywhere. A half sister showed up from out of state and was able to claim a big share of the estate instead of it going to his niece and nephew because he
Wow.
lost his will.
Wow, wow, wow. Mm.
Well, personal story. My dad did a will and got some of those kids' name wrong. Okay, so I'll give you on birthdays, I'll give you on social security number, but names.
Wow. Yeah, well, it's a lot. It's a lot to think about. It's very important that again you have the conversations and things be taken care of. One of the best gifts that you can actually give to your family members is to have a lot of this stuff planned and taken care of long before you actually pass away. Because again, there's nothing like trying to go through a grieving process and then still trying to handle family affairs at the same time, especially when you've got a mortgage or if you've got kids that need to be taken care of. Somebody needs to get access to bank accounts, to retirements, to whatever, in order for them to move forward and to maintain. So give your family that gift of making sure that things are actually taken care of beforehand. So with that being said, the recording of this session will be emailed to everyone, along with the links that were mentioned throughout the presentation, a list of the resources, as well as part 1 of this presentation, which is about wills and estate planning and why it is that you need it. I will email that link along with those documents that actually make up an estate plan. If you want to draft your own and what does that actually look like and the language that needs to go in there, the power of attorneys documents, the HIPAA forms, the transfer on death deed, all of those templates are sample templates that you could use that will be included in the email that I send out to you guys. And in preparing those documents, if you do it yourself, like Ms. Lisa mentioned, on the 24th, I believe it is this month. Yes, on the 24th of this month, we will be back at the Sunnyside Multi-Service Center. Let me make sure. Yes, Sunnyside Multi-Service Center on Reed Road on the 24th from 10 a.m. to 12 p.m. You will have the opportunity to come out. And if you have questions about your tax bill and you want to talk to the tax office, or if you have a question about different exemptions, or if you want to have an attorney to look over those documents for you, attorneys will not be preparing documents for anyone. If you would like to apply for the services of any of the legal service partners, you will have the opportunity to do that and have intake done for you, but preparation of legal documents will not be done at that time. They will not be allowed to do that. So, but again, if you just want to ask questions, you want to talk to somebody, or just need other resources or other information, then make sure you come out and see us on the 24th. We will be there of this month. Yes, ma'am, Miss Mabel, you have that look on your face. Write it down.
Go talk.
Write it down. We will be there on the 24th. So with that being said, Miss Jamie, you put your hand back up. You had something else to add?
No.
Oh,
Did
I
I?
see the
You
hand
put
up.
your hand up.
Yeah.
Oh, no, let me take my hand down. Sorry. Whoops. I think it was just, sorry, my mouse was moving all over the place.
All right. Is there anything else that you all would like to add or any information?
I hope we see a lot of people on the 24th. We look forward to seeing you in person.
Likewise, likewise. All right. You all have a wonderful remainder of your afternoon. Take care of yourselves, stay safe, and we will see you all next time.
Be blessed, everyone. Take care.
All right.
Thank
Take
you.
care.
Bye.